Hello, so this is chapter 6, where we start looking at contract law. We'll have actually four chapters for contract law, being it one of the most important legal topics in this course. So, in both chapter 6 and 7, we'll look at the elements of a contract, and you see that a valid contract or a contract will be only valid when those five elements we'll be discussing are present in a contract. So we'll first understand the basics of a contract and then look at consensus, which is one of the five required elements, being it the first we'll look at. Consensus is actually made of a valid offer and effective acceptance. We'll look into details of those. And then the second required element is consideration. And consideration is either the price to be paid by both parties or the mutual benefits for both parties as well. And there are some exceptions for consideration, some details that are very important. So basically, those are the two required elements we'll look at. And then in chapter 7, we'll be looking at capacity, legality, and intention as the as the three other remaining elements, required elements out of the five. So what is a contract? A contract is actually when parties, usually two, but it may be as many as possible, but usually two parties, they voluntarily, meaning not under threat, not under any um, mandatory aspect. It is voluntary. They want. So parties voluntarily exchange promises. So when you buy coffee, you are promising, you are voluntarily promising to pay the price, and the coffee shop is voluntarily promising to give you the coffee you're ordering. And once there's this exchange of promises, then they become obligations. So you are now obliged to pay for the coffee. They are obliged to give you the coffee. And if any of the parties defaults, or if you don't pay the full price, or if they don't give you the coffee, or if they give you a different coffee, then you can use the courts to either enforce the obligation or your benefit. So they can sue you for the price you didn't pay, or you can sue the coffee shop for the coffee they didn't give you, or you can get it. You can have other remedies. Um, you can get compensation as damages, or any other damages we'll see um, in chapter 9 later on. Okay, so again, parties they voluntarily exchange promises, and those promises then become obligations. And in case any of those obligations are defaulted on, or those obligations are not performed um, substantially, then the victim, the other party that was expecting for those obligations to be performed, they may enforce those obligations in court, or they may seek other remedies. Okay, two important principles related to contract law. The first one is freedom of contract. So parties can enter into any contracts they want in any way they want. The only exception here will be prohibitions that are in the law. So we'll see in chapter 7 some types of contracts that are illegal. In other words, the law prohibits parties to enter into those contracts. But those are exceptions. The general rule is that parties can enter into any contracts as they want. any type of contracts, any terms, etc. And in most cases, courts they will respect the parties' freedom to contract. Courts in general, generally speaking, they don't like to rewrite contracts whenever one party challenges a contract at the court. Judges don't like to rewrite. They either give the meaning that it has to be given or they avoid the contract. They cancel the contract. Okay, but we'll see this in more details later on. And there's also this civil law system principle that is the duty of good faith. And the civil law system principle was borrowed. Um, so the common law system borrowed this principle from the civil law system, and the duty of good faith is also present in common law system. So it is, in other words, the duty to act in an honest way, not only performing the contract, but also during the negotiations. So at any time you are engaged in a contractual relationship. So that's the duty of good faith. So the elements of contracts, they are the five elements are consensus, consideration, capacity, legality, and intention. So in chapter 6, we're looking only at consensus and consideration, and we'll see them in details later on. One other very important thing, this is very, very important. Verbal agreements are as binding as written one. Yes, a contract does not need to be in writing to be valid. A contract may be verbal, and by the way, most contracts are verbal. Again, when you're buying coffee, um, do you have a contract which you give to the coffee shop to sign? No, we don't do this. So we just verbally say, may I have black coffee, may I have dark coffee, may I have double double, etc. So you are verbally exchanging your promise that will become an obligation. And the coffee shop staff, they will reply saying, yes, it's $2, $3. So it is a verbal agreement. A lot of employment agreement are also verbal. So the applicant goes to an interview, usually for low-paying jobs, and then after the interview, they are asked, "Can you start right away, or can you just start tomorrow?" So it is a verbal agreement. I'm not saying verbal agreements are the best ones. No, it is difficult to make evidence in court. It is difficult to prove you actually had a verbal agreement. But evidence is something different from the right, from contract law. What I'm saying is, even though it may be difficult to prove a verbal contract, it doesn't mean you didn't have a contract. Okay, so that's why it is highly recommended to be on a written agreement, even though verbal agreements are as valid, as binding as written ones. Okay, keep that in mind, very, very important. Some terms and definitions that are important for contract law. So contracts, they may be express meaning the terms are clear, the terms are either spoken out or written, or contracts may be implied. And what does implied mean? Implied means by conduct. Let me give you this example, and I'll touch upon this example again later on. But when you hail for a cab driver, so by conduct, you are offering to pay for a ride. And when the cab driver stops and picks you up, the cab driver is actually by conduct, from conduct as well, is telling you, oh, I'm driving you from this point to where you want to be, and I will be paid for that. So this is a conduct, sorry, this is a term that is implied from conduct. So when you are paying for the coffee, you actually you order the coffee, but by paying, um, you are accepting what you're getting. So the difference between express and implied. We also have valid, void, and voidable. So valid is straightforward. Void is null, inexistent, is not legally binding. So if you are ever in a void contract, you don't need to perform your obligations because that contract is not binding, not legally binding. And we have voidable. Voidable is different from void. Also very important to be able to distinguish. Voidable is a contract that is valid, legal, in principle, but there may have been some issues while forming the contract that may cause the contract to be void. So, in principle, it is legal, it is binding, but it may become void. Why am I saying it may become void? Because it depends on the victim to actually challenge that contract, that agreement, to make it void. But if the victim never challenges it, for whatever reasons, they don't want to bother, they don't want to pay legal fees, etc., the contract is still legal and binding. Okay? So again, a void contract is a contract that is null, inexistent in terms of obligations, in other words, not legally binding. And a voidable contract is a contract that is in principle binding, has its legal effects. However, it may become void, may become void. Contracts are also unenforceable or illegal. Well, there are contracts that are legal, but because they did not comply with the specific requirements, and those specific requirements would be related to some specific transactions we'll see in the future. So, one example here, there are some types of contracts, some type of business relationships, which the law requires contracts to be in writing. Again, that's the exception because I told you verbal agreements are as valid as written agreements, but there are exceptions. One exception is contracts that are longer than 1 year. So a supply contract, this company is getting product supplied by a supplier, and their contract is 5 years long. So the law says this specific contract would need to be in writing. However, if this contract is not in writing, it is still a legal contract, but not enforceable. It means courts will not enforce this contract in case any of the parties challenge this contract in courts. Okay? So a unenforceable contract is one that is legal but cannot be enforced by the courts. And any legal contract is a contract that has an illegal object. We'll see this in more details and many more examples in chapter 7. For now, I'll just tell you that illegal object matters such as drugs. When you buy drugs, or anyone who buys drugs, anyone who sells drugs, they are in an illegal contract, meaning parties are taking their own risks, their own chances, because this is not a contract that the law recognizes, regards as a legal one. The last two terms or important terms are bilateral and unilateral. So a bilateral contract is, most contracts are actually bilateral because it is a contract in which there will be commitments, there will be obligations, and there will be benefits on both parties. So most contracts are bilateral. Purchasing a coffee example. So my commitment, my obligation is to pay for the coffee. My benefit is to get the coffee. The coffee shops obligation is to deliver me the coffee, their benefit will be the money, the profit they make out of the sale. A unilateral contract is a contract that there's no exchange of promises. Actually, the best example here is when you see a sign of a lost pet, and in the sign, it is being offered a reward if you find them. Well, anyone could look for the pet, so you would be making, uh, you would be um, making an effort to find the pet. However, you only get the reward if you find it. So unilateral contracts are those of rewards when rewards are offered. Only one party, the party performing their obligations, they need to actually perform uh, to the latest, meaning they need to actually find the pet, find the lost item, so that they get the reward. If they look for it but they never find, they will never get the reward, meaning the person who offered the reward would never need to pay for that reward because the item, the pet, they were never found. Okay, so that's a unilateral contract example. So let's start looking at those two required elements, consensus and consideration, because the three other ones we'll look in chapter 7. So consensus is actually when the minds meet. When do minds meet? Well, when that voluntary exchange of promises, when they meet, I voluntarily promised to pay for a coffee, and the coffee shop voluntarily not accepted, sorry, but voluntarily promised to give me the coffee. So it means, in legal words, that our minds met, and then we now have obligations. So we are actually willing to commit ourselves. I'm willing to pay for the coffee. They are willing to deliver me the coffee. Okay, and we cannot claim as a defense that we failed to read a contract. So when you buy your cell phone plan, when you enter into that agreement, we usually never read because most likely they send us by email. But still, if there are things that we don't agree, um, in principle, we cannot use as a defense that we failed to read or we didn't read it. Okay, so even though we have protections under consumer legislation, if there are abusive clauses, abusive sections in those types of contracts, keep that in mind. We can never use as a defense that we failed to read, we didn't um, understand, or not have an opportunity to read the contract. And consensus, as I told you in the very beginning, consensus is made of a valid offer and an effective acceptance. So we need to look into details of offers and details of acceptance. So an offer is when you are the coffee example again, you are ordering black coffee, medium black coffee, small black coffee, no milk, two milk, one sugar, two sugar, no sugar. So you're actually speaking out the terms of the agreement. This is the offer. You are offering to buy a medium black coffee, no sugar, one milk. Those are the terms. Okay, you're offering to buy a house, or someone is offering to sell their house, and then they have the house address, the house size, payment terms, closing date. Those are the terms, and those terms they have to be communicated. They have to be either in writing or spoken out. They have to be clear. Okay, an offer may also be subject to. Subject to means an offer that is dependent on something else. An offer that depends on something else to happen so that that offer becomes valid. So, for example, simple example, I will buy your car, so I'm offering to buy your car as long as I sell mine. So I need to sell mine to make some money, and then I will buy yours. So when I make this offer, I want to buy your car for $100,000 as long as I sell mine. My offer to buy your car is not valid until I sell my car. So until my condition is met. This is a subject to clause. This is a condition clause. This is actually known as condition precedent. We'll see this again in chapter 9, but it's important to mention now in terms of an offer. This is also highly used in purchasing real estate. So purchasers, they usually make an offer to buy a house, townhouse, apartment, but they have a condition there. They say, as long as or dependent on my securing a mortgage. So if I don't get the mortgage, if I don't secure the mortgage, the purchase offer is not valid. However, if I do secure the mortgage, then the offer becomes valid. And only valid offers can be accepted. Okay? So that's what a subject to clause means. This is very important, and by the way, you may have questions in your exam uh, based on this invitation to treat an offer by conduct. So, an invitation to treat, it is not an offer. So, we have to be able to differentiate when we are invited to treat, when we are invited to negotiate, as opposed to an offer specifically. So an invitation to treat is when we are being invited to make an offer ourselves. Examples are when we see advertisements, when we see sale promotions. So you may have seen on the flyer this weekend sale for this Porsche. We are waiving the Porsche car dealership. They are waiving 3-month payments. So this is not an offer. They are not offering to you. They are just inviting you to treat. So you would get this flyer. You would go to the Porsche car dealership and you would say, "Hey, I would like to purchase this Porsche based on this invitation to treat, based on this sale promotion." Okay, so that's an invitation to treat. It is not an offer because an offer has to be directed to a specific person, and that is just an advertisement. Articles in the supermarket, so articles that are displayed in the grocery store, uh, they are not offers. They are just inviting us to offer because we pick goods. We're going to grab all goods we want, and then we are going to place at the cashier's desk and we are making the offer, and we are making the offer by conduct because we don't get to the cashier's desk and say, "Hey, I would like to make an offer to buy all those items." No, we don't do this. Just by conduct, by placing the items there in the cashier's desk, we are making the offer to buy them, and the cashiers, they are accepting our offer by conduct as well. How? They just scan the products and then they charge us the price. Okay, so articles displayed, advertisement, sale promotion, even though they use the word, sometimes they use, oh, best offer in town, but it's just an advertisement. Legally speaking, it is not an offer, it is just an invitation to treat. Okay, an offer by conduct is this one I just exemplified with the goods at the cashier's desk, or the one I exemplified before, taxi driver, when we hail to a taxi driver when they stop. This is offer by conduct. Okay, So an offer has to be communicated, cannot be in silence, and it has to be communicated to the group or to a specific person you want them to accept or not. Okay? Exemption clauses. What are exemption clauses? So a good example here would be when we go to Best Buy and they want to sell a product that has been on display for some time, and this product may have some minor scratches on the screen, the keyboard may be dirty, so it means they want to offer a discount for this item on display, but they also want to exempt themselves from liability. What kind of liability? Liability on those minor scratches, liability on that dirty keyboard. So this is an example of an exemption clause. It is when uh, the one the one advertising the product is also trying to exempt themselves from a specific liability. So those exemption clauses, they have to be brought to the attention of the person who aims to purchase the product. So they have to say, item on display, we are not liable for those minor scratches and dirty keyboard. If they don't do this, while displaying the product, if they just inform you later on, after you purchase the product, that exemption clause is not effective. That exemption clause will not be valid. Okay? So before you purchase that product, you need to be aware of that. Another simple example, sometimes you go to restaurants and they say, we do not accept credit cards. So they are exempting themselves from, or they are telling you advance that you will have to pay even if you have only credit card, because you were told in advance that they did not accept credit card payments. Okay. When does an offer end, and why is it important to know when an offer ends? It's important to know because an offer that has ended cannot be accepted anymore. So I made you an offer. Would you like to buy my car for 10,000? And let's say my car is worth 20,000. So it's a big discount there. But I'll tell you, you have to tell me in 5 minutes. If not, this offer is ended. So after 10 minutes, you come to accept it, and I say no, it's ended. I told you you had a 5 minute offer. So we can only accept offers that are valid, that are still there. When they have ended, we cannot accept ended offers anymore. So an offer will end after a specified time. So as I just told you, after 5 minutes, or when the offeror, the person who made the offer, dies or becomes insane. So that offer is not valid anymore. Or when the offer is revoked. What is to revoke an offer? Is to withdraw an offer. Is to say, hey, no, forget about that offer. I'm revoking it. I'm withdrawing it. So the offerer is the one who will revoke or withdraw an order. However, revoking or withdrawing an offer just ends an offer if it is before acceptance. Because if I made you an offer and you already accepted, we have a contract if all the other required elements are there. So what I'm trying to say here is that if there's an acceptance for an offer, the offer cannot be revoked anymore. Okay? So revoking has to be before acceptance, and also it has to be communicated. So when you make an offer to 10 people and you want to revoke the offer you made to all of them, you need to reach out to every one of the 10 people to revoke the offer. And again, before acceptance, because if anyone has accepted it already, you cannot revoke the offer anymore. When the offer is rejected, so when the offeree, the person receiving the offer, when they reject the offer, so would you like to buy my car for 10,000? And you say, oh no, thank you, I can afford it. You have revoked, you have rejected the offer. So that offer is has ended for you. Okay? The offer is not valid anymore. When there's a counter offer, what is a counter offer? Counter offer is actually rejecting the original offer and to making a new offer. So I make an offer to you. Would you like to buy my car for 10,000? You say, no, not for 10,000. Well, you have just rejected my offer. So my offer is ended. But then you go on and you say, but I'm interested to buy it for 9,000. So you just made a counter offer. But a counter offer, in other words, is actually a rejection of the original offer plus a new offer, but a new offer coming from the offeree, not from the offeror. That's what a counter offer is. Okay? When the subject matter is illegal, so if I offer you to buy drugs, let's say. So this is an illegal offer, and the offer doesn't exist. And when the subject matter is destroyed, well, this is interesting and important as well. So let's say I offer you to buy my car for 10,000, and you say yes, yeah, I want to buy it, 10,000. Okay, so we have an agreement. However, unknown to both of us, my car was destroyed. Let's say my car caught fire, my car was stolen, and it has to be unknown to both of us because if I knew my car was destroyed, and even though, sorry, even though I offered it to you, then I would be lying. This is something we're going to see in chapter 8. But unknown to both of us, the object matter was destroyed, then the offer is ended. There's no contract, no valid contract there. Okay? Right. So some offers that cannot be revoked, when you make an offer and then you want to revoke it, you want to withdraw it, those are some you cannot. So the unilateral offer, remember I told you the reward for a lost pet, for example. So when you put a sign for a reward, and then you cannot revoke it because there may be people looking for your pet that you don't even know. So you cannot revoke a unilateral offer. Tender, when you make a tender bid, let's say there's this company, they want to buy some, let's say, printer supply. So they release a tender because they want to know which supplier can offer the lowest price. So the suppliers, they send their tender bids, and once they place their tender bids, they cannot revoke them. They won't be able to revoke them because they may be the one chosen to sell the products. And also option agreement. An option agreement is an agreement in which you are actually buying time. The option agreement is not the agreement to buy the asset per se, but just to buy time. So, for example, you want to buy my car, but you still need to sell yours. Or you need to get money from the bank, you need to get a loan, for example. So you say, hey, João, let's come into an option agreement where I will buy your car, I may buy your car in about a week. So we enter into a 1 week option agreement. You pay me some money, let's say $100, $500, but this money you are paying me is actually for the time, is for me not to sell my car to anyone else within this 7-day period, within this week. And you making this, you made this offer and you paid me this money for this option agreement. You have the right to buy my car within this week period, within this 7-day period. It doesn't mean you have to buy my car. It just means that you may. I have to sell my car to you in case you come back to me and you say, hey, I want to buy your car now. This is very, very common for land transactions again, for house, for property. Remember, I told you the subject offer, the subject, the condition precedent. So I will buy your house if I secure mortgage. But it may take me a week, 30 days, 60 days to secure mortgage. So on the top of this conditional offer, we can also enter into an option agreement because while I'm trying to secure the mortgage, I don't want you to sell this house to anyone else. Okay, so that's the option agreement. You are just buying time. You are not buying the asset you are interested in. And why are you buying time? You are buying time because you want to manage, you want to meet some conditions, you want to reach certain circumstances that will allow you to purchase the asset. Okay, let's say in my example, I like a car, but I need to have my wife's authorization to buy a new car. So I would come into an option agreement for 1 day so that I could try to convince my wife to allow me to buy the new car. And then I would buy the car or not buy the car. Okay, so that's an example of option agreement. And those offers, they cannot be revoked. Okay, so they are exceptions of being able to revoke an offer. Standard form contracts. Well, all contracts that we as individuals we don't have an opportunity to negotiate, they are known as standard form contracts. They are known as uh, take take it or leave it. So you either accept it or you just don't purchase. Good example, airline tickets. So when you buy an airline ticket, do you read the airline agreement, the transportation agreement? And even if you read, if you don't agree with some clauses, do you call the airline and say, hey, I don't agree with this clause 14, section 21. Can you please change to a better wording, etc., etc.? No, we don't do this. And it is one party, usually the seller, they drafted this contract and they don't negotiate. Why is it important for us to know that standard form contracts exist? It is important because even though we could not negotiate, we still have protections. And in most cases, we have protections from uh, consumer legislation. So in consumer legislation, if sellers um, they abuse on our rights, they limit their liabilities too much, we may still sue them, challenge those sections, those clauses in court, and the courts will read those sections, those clauses. Um, in most cases, they will favor the consumer because they know the consumer had no opportunity to negotiate them. Okay, so what I'm trying to, as what lesson do we learn from this standard form contracts? The lesson is that we it's okay if we don't read them those contracts fully in details because in case we were abused on, we may still have resort, we may still have remedies available in courts. Okay, so now looking at acceptance, we discussed about offer, and remember, offer and acceptance, they are related to consensus. The requirement is consensus for a valid contract, and a valid contract is requires consensus to be there, requires an offer to be valid, and it also requires an acceptance to be effective. And what is acceptance? Well, it is when the offeree says, speaks out, or signs, confirms in writing their intention to commit. They intend to commit to that offer. And acceptance has to be unconditional because if the offeree adds conditions to the offer, it is actually a counter offer. It is actually including, adding new terms. So if you change the offer when you accept it, you are actually making a counter offer. And you already know that a counter offer is actually rejecting the original offer and the offeree making a new offer. Okay, so that's acceptance. And acceptance has to be communicated. Sometimes there will be acceptance by conduct. The cab driver example I gave you, the cashier scanning the goods at the grocery store example I gave you. For unilateral contract, the acceptance will be when you actually find what you were looking for, when you actually complete your performance, when you fully perform your obligation. So that's the acceptance for unilateral contracts. And the acceptance is effective when it is communicated. So you made me an offer and the offer is still open in the next day. So next day I call you and I say, hey, I'm accepting your offer. So it is in this next day that the offer is considered to be effective because I only accepted in that next day. Okay. And also, if you take the benefit of an offer, you have accepted it. Okay, so if you when you pay for a product, even though you haven't delivered the product yet, so let's say I order a coffee and then I was charged $2. I paid this $2, but then they say, "Oh, coffee is over. We don't have coffee anymore." Well, because you got the money, you accept it. Now you have to either compensate me, give me back my money, or try to get coffee somewhere else because you accepted the benefit of my offer, which was paying for that coffee. Okay, so those are ways to communicate an acceptance because communication is necessary for acceptance. Silence is not acceptance unless it is ongoing business relationship. Well, you have a company that get products from different suppliers. They send you a new offer by email saying price is going a little bit up or changing the terms and conditions, and you don't reply to that email, but you keep on receiving the goods, etc. So silence is only effective in such example. In general, communication of acceptance is required. In other words, silence is not acceptance. We have the post box rule. This is important. Post box rule only for written acceptances. So email, fax, they don't count here. Only for acceptances in writing by mail, regular mail. And I know this is not so common nowadays, but still, the law is still there. So when you mail your acceptance, your acceptance is considered to be effective at the time and where you posted your acceptance mail. So let's say this company based in Ontario, they made you an offer and you must reply to this offer by mail. So you mail this morning your acceptance. It means your acceptance is already effective, even though the offerer in Ontario they have not received your acceptance yet. Okay, so here is the important aspect of it. Even though the offerer is not aware the offeree has already mailed their acceptance, the offer has been already accepted. And what is the consequence for this? The consequence for this is that the offerer cannot cancel, cannot revoke, cannot withdraw the offer anymore because the offer has been accepted already. Okay? Remember here when we discussed about ending an offer? An offer will end One way is by revocation of the offer or withdrawing, but only before acceptance. And if I just told you that when you mail, so you mailed this morning, you went to the post office and you mail your acceptance, it means you have accepted already. So after this morning, the offerer, even though the offerer is not aware you have already mailed the acceptance, they cannot revoke, they cannot withdraw their offer. Okay, so post box rule, very important, and it is applicable for mail um, acceptances. Okay, not email, not others. So here you have chart of what I just explained to you. How a contract is created. So there are invitations to treat. Those invitations, they usually lead to negotiations. And then there will be an offer. There may be counter offer or not, but only when the offer is accepted, the contract is formed. So an acceptance is required so that consensus is formed. That's why in the very beginning I told you that consensus, this first requirement, is made of a valid offer and an effective acceptance. Okay, then consensus is formed. So for electronic transactions, the one thing I want to share with you is that electronic contracts are valid, and when we click on I accept those terms and conditions, I accept this purchase. So by clicking that, we are accepting the offer that was made to us. Okay, so that's mainly what I want to share with you. So now consideration. Consideration is the second required element for a contract. And consideration is actually what parties, the price parties will pay. So when I purchase coffee, I have to pay $2. When the coffee shop sells me coffee, they are actually delivering me the coffee. So the price I am paying is actually money, and the price the coffee shop is paying is actually stock. So they are getting rid of their stock. So there's both parties pay the price and both parties derive the benefit. So this mutual benefit is also a definition of consideration. Because what was my benefit? The coffee I purchased. What was the coffee shop's benefit? The money, the profit they made. So all contracts need consideration as a required element. In other words, all contracting parties, they have to derive a benefit. They have to pay a price. Because a contract in which only one party derives a benefit, only one party pays a price, is known as a gratuitous promise. It is not a contract actually. And gratuitous promises, they are not enforceable. They may be legal, as I told you in the beginning, but they are not enforceable, meaning courts will not enforce. So let's say the coffee shop is giving for free coffee, and you get there, um, and they don't have coffee anymore. So they ran out of coffee they were giving away. And you say, hey, but you promised to give coffee. I listened to you on the radio, etc. Well, but it was free. It was a gratuitous promise. If they don't have coffee anymore, it's okay for them not to give to you. You cannot sue them because courts will say, hey, that was a gratuitous promise. You are not paying for it. If you were to pay, then there would be mutual benefit. Both parties would pay a price. So that's what consideration is. And when there's no valid consideration, the contract is not enforceable. We'll see some more examples in a minute. So consideration, this price to be paid does not need to be fair. Maybe I'm selling coffee and I'm charging 10 cents for each medium coffee. It's fine. It's not fair, but it has a material value and can be stated specifically. So that is fine. Okay, being fair or not is doesn't influence the validity of consideration. Now, talking a bit more about gratuitous promises. Well, so let's say here we have to detail a bit more in terms of past consideration or existing duty. Okay, so I'm purchasing coffee, and I'm trying to use the same example so that it's easier for you to memorize. So I'm paying $2 for coffee, for a medium coffee. Okay, so there's an agreement, and that was accepted. I paid already. Sorry, I didn't pay. Or yes, I paid already. But then when they deliver me coffee, they say, "Oh, sorry, I don't have medium coffee. I just have small coffee. Is this okay?" And I say, "Well, you're getting less. You're not getting what you actually ordered. So that is not valid consideration. That is, if they say, oh, or let me change the example. We are paying for coffee. So I should pay for coffee, for medium coffee, but I just paid $1 and I should have paid two. I thought I had $2 with me, but I didn't have $2. I only had $1. So I paid one, or before paying one, I get the coffee and I say, hey, can I actually pay one for this coffee because I don't have two? Uh, this is not valid consideration. Even though you are paying something, but you are paying less than the original agreement, because the original agreement was $2, for example, for the coffee. So an existing duty, when you already have a duty because you already exchanged a promise, you cannot change it. Past consideration is the same example I gave you here. But I like to bring this employment relationship example. Uh, so you are working well, you started, let's say, 6 months ago, and your boss comes to you and says, hey, I'm giving you a raise by the end of the year because I like the way you work. So the way you work is actually the obligations you committed when you signed the employment agreement, and you are doing your best. It means, in other words, the company, the employer, your boss, they are offering you a gratuitous, this is a gratuitous promise. They are offering you in exchange, not in exchange of something new, but in exchange for something they already have. You have already exchanged it with them when you sign the employment agreement. So what I'm saying is, if by the end of the year, hopefully you get this raise, but if you don't get the raise, you cannot sue your employer because that was a gratuitous promise. That was what you offered as consideration, which was working well, keeping on working well, is actually a past consideration. Could be an existing or a past consideration. It is not a new consideration. So you would, to get a raise when you are offered, well, not to get a raise because that gratuitous promise may be complied with. Your boss may actually give you the raise and done. But for such agreement to be enforceable, you would need to also offer something in exchange. Oh, I appreciate you offering me a raise, and because of this, I'm gonna work, I don't know, 10 minutes more every day, or I'm gonna get one more duty that I don't have as of now, etc. So if you do this, it means that um, exchange of promises actually has a valid consideration because both parties would be paying a price between quotations, or both parties would derive a benefit. Okay? There's an exception here when someone offers to pay less to satisfy a debt, even though this paying less is actually a past consideration, but courts usually accept as a valid consideration. The way courts look at it is that, well, the person had a debt. They defaulted paying the loan, for example, repaying the loan. So the creditor would get zero, would get nothing. Now they are at least getting something. So because they are getting something, at least something, courts understand that this is a valid agreement because there's valid consideration. Okay? So that's how courts see, specifically for paying less in order to satisfy a debt. And when there's no consideration or illegal consideration, the contract is void. The contract has no legal effect. That's why I told you if you were promised a raise, you didn't give anything in exchange, and then you don't get the raise, you cannot sue because there's no valid consideration, no valid agreement. A settlement out of court may be a valid consideration as well. Courts like when disputes are settled by parties, so that is fine. What else? So some exceptions for consideration. And the simplest one is sealed document. So whenever documents are sealed, uh, no parties can challenge, can debate about consideration because sealed documents are considered to be under valid consideration. And promissory estoppel. This is very interesting. So if you rely on a promise, but then that promise is not complied with, and you end up having a loss, a negative effect, then you can enforce that promise, that gratuitous promise. So again, the employment example. Your boss offers you a raise by the end of the year, and you don't offer anything in exchange. However, you rely on that raise to start a new course, to buy a new car, to go on vacation and travel. So you make plans where you would use this raise. But because you don't get it, so if your boss doesn't give you the raise, you will have a loss. You will have negative effects. So in this case, you could sue the company. You could sue your boss because you relied on the promise. You actually made plans to use that money. Because you didn't get the raise, you suffered loss. Then you can enforce a gratuitous promise, but only in this promissory estoppel example. Okay, so here's the chart for promissory estoppel. And yes, that's chapter 6, talking about contract law. So we started talking about contract law. We started looking at the 5 required elements for a contract. We looked at the first 2, consensus and consideration. Consensus being valid offer and an effective acceptance. Consideration being price to be paid by both parties, the benefit, the mutual benefit for that contract. Okay, thank you and see you again on chapter 7. Bye for now.